Good afternoon, everyone. I just wanted to talk real quickly with you about the Q-Son Judkins case. It's a criminal case out of Broward County, and being a Florida attorney provides some insight. Because originally reviewing the report, this alleged incident occurred, I believe, July 7th, but he wasn't arrested until the weekend, and that's going to be problematic for the prosecution in these types of domestic violence cases. I probably handled 1,500, I would say, when I was prosecutor, or handled countless number of them since I've been a defense attorney. And in these types of situations, it's victim cooperation is pretty key to being able to move forward with charges. And if you can't, is there sufficient corroboration? Reviewing the report, the victim doesn't call 911 until after speaking with her family. So there's not going to be any kind of excited utterances. There's no 911 call. She turns over a photograph of what she looked the day after the incident with some bruising, but that's going to be hearsay, not within an exception likely, if she's not cooperative, because then there's a situation where there's no ability to authenticate it. An officer can't be like, yeah, this photograph is what they gave me. It's likely not going to come in. So reviewing the police report, I still think it's in the same situation as it was over the weekend, where I don't think this case is ultimately going to move forward or result in any kind of conviction. Some kind of overzealous prosecutor may try to charge it, given the publicity, but I don't think there's really that much there. If the victim wants to cooperate, they might be in a position to move forward on the case. But even still, the case is still a he said, she said situation. And without a 911 call, without jail calls, it's going to be very difficult to be able to prove that case beyond a reasonable doubt. The defendant made the right decision invoking his Miranda rights. There's no good ever speaking to law enforcement ever, because if you confess, they're not going to be like, well, we appreciate you being honest. No, they're just going to put in their report and arrest you, and the prosecutor is going to think they have an easy case. So I think what the ultimate result is, I think this case ultimately gets declined. If it's not declined, I think it'll end up being no pros. And the difference between a decline and a no pros is a decline. It happens before charges are formally filed. So in the state of Florida, in order for Mr. Judkins to be formally charged with domestic battery, the prosecutor assigned in Broward County needs to file what's called an information. That's a formal charging document. And if they fail to do so, then it's called the decline. But if they file the charges, then later decide that they want to dismiss the case, they file what's called the no pros. And that occurs after formal charges. But for now, I just don't see this case going anywhere. The league may look into the case and may issue a suspension, but I see that as unlikely, just because without victim cooperation, I don't see this case going anywhere. From Matthew Timpanek of Timpanek Law, thanks for stopping by and joining us.